Hi, everyone. This is immigration lawyer John Khosravi. Thank you for joining us on a special episode number 170. It's special because we have Kevin Gregg on, our regular guest that comes on every month to talk about recent federal litigation updates, but also doing it live on this private the private Facebook group, and also on the YouTube page for immigrationlawyerstoolbox.com or Immigration Lawyers Toolbox. As you see us live, so we're getting a little nervous, but I want to make sure I mentioned a couple of things before we get Kevin on. First of all, the Champions for Freedom training program for marriage immigration cases is going, and it's going strong. A lot of users, a lot of new immigration attorneys, existing ones who are trying to get into that area of practice are getting it. Please email me at info@immigrationlawyerstoolbox.com if you wanted more information about that. I also want to thank our regular sponsor, DocuWise. It's a great service that provides, form services at the basics, but they also have all sorts of office management tools, keeping track of time. Their forms could be translated into various languages that they keep adding. It's just a great service and a great team in charge. I know them personally, so I know that they really care about what they're doing, and it's something they're obsessed with. And they've always supported the podcast and Kevin's podcast as well, Immigration Review, which I highly recommend listening to. So it's a great service. And so if you want to get 10% off the annual plan, just go to an additional 10% off www.docowise.com/immigration-lawyers-podcast and include the code Immigration Lawyers Podcast to get that. What else? The Immigration Lawyers Toolbox magazine is going to be coming up in probably a week. It's a lot of work, and I can't wait for Kevin to write an article for the next issue. But we're going to be getting that in, and I look forward to that. It's just a lot of work, a lot of just all obsessed with. But I'm going to really put the links out, all that when it comes out next week. And if you're listening, wherever you're listening, like, subscribe, leave a 5-star review. Much appreciated. It will be great. This is not legal advice, not intended for individual legal advice. Consult with an attorney. And if you have questions, email me at info@immigrationlawyerstoolbox.com. That's the official email. On the live feed, if you're watching the video, it has my website, my law firm email there, because this software doesn't let long email addresses in there. So with that, Kevin, I forgot to even mute you, but it was good having your laughter in the background. Thanks for coming on today.
Well, I think I unmuted myself, so I think I got you, and I got the. No, I will absolutely eventually submit an article for the magazine. When I grow a third hand, and then a second brain. Thanks for having me, John. It's a pleasure to be here. You have a lovely background. I'm always happy to speak with you. And hello, world.
Yeah, it's a special. We got to be careful. No pauses, no mistakes, because we're live. We're on. People can leave comments. Apparently, if anyone's woke up early on a Sunday morning like this, feel free to leave stuff, and we'll try to answer questions if we can. But so, Kevin, what's going on with you?
Well, this is my morning pre-surf podcast. You get the podcast in. Then I'm going to try and surf in San Diego. It's been raining a lot, but I think I'm going to go out there. I'm gonna try and do it. I'm doing what everyone else is doing. I'm hunkering low. I'm staying in the house, working hard, and hoping everybody gets their shot. My fiance and I have postponed our wedding for the 4th time.
Oh boy.
Well, no, 3rd time, so fourth date. But August is the final date. We'll all be good.
We had a user saying it's the first time to see what Kevin looks like. Well, that's great. That's the
man. I'm positive you're disappointed. I cannot believe you're not disappointed.
Sometimes the voices don't match its face, but you hear someone on the radio a lot, and then you see the face. You're like, well, I imagine something completely different. Not that they're disappointed, but it's just unexpected.
So, John, you and I both have faces for radio.
Yeah, or podcasts nowadays. But let's just jump into it. What cases do you want to talk about this month?
So every time I've appeared on your show, I'm trying to do just the last month's cases.
Yeah.
And, I looked into what's been happening the last month, and there's some interesting stuff. I try and highlight the wins when I do that. Mm-hmm. But I'm going to just say off the bat, the 2 most interesting recent cases are not in the month of January. Well, they are in the month of January, but they haven't dropped yet on the Immigration Review podcast. So I'm only going to tease them. And those are the ones that came out last week. I know you're in the 9th Circuit. I'm in the 9th Circuit too now. Carr v. Wilkinson out of the 9th on January 29th. And Amaya v. Rosen, although I think it should be Wilkinson, and the 4th Circuit just didn't change the Attorney General yet, out of the 4th Circuit on January 25th. And they're both asylum cases. Mm-hmm. And just to tease them, Carr v. Wilkinson essentially says attempted rape always is past persecution. Nothing more is needed. It's a horrendous thing. And Amaya v. Rosen refuses to grant Chevron deference to the Board of Immigration Appeals in matter of WGR, which is the 2014 companion case to matter of MEVG about particular social groups. And WGR essentially said, former gang members or witnesses, I cannot actually recall exactly, is not a particular social group. And it was about particularity. And then WGR is used to say that groups that are too big, usually, can't be particular. And it's based on country condition evidence. You have to look into the country to see if it's particular in that country. And the Fourth Circuit said, no, that's not how particularity works. Particularity is just whether or not you wrote it definable. And so there is no limit to the size. So as I read it, and as a lot of people read Amaya v. Rosen, it's a really big case. It opens the door for gender-based particular social groups. It just kind of stops a lot of the nonsense over what's been happening with particular social groups over the many years, and it shifts the focus to the nexus and social distinction. So that was me saying I wasn't going to talk about those cases. God forbid what happens to the cases I said I was going to talk about, but I'll talk more about that tomorrow when the Immigration Review podcast drops.
Cool.
Yeah.
So what are the cases that you're thinking about talking today?
Well, having discussed those so much, I was kind of going to do a run through. It's kind of a weird month for cases, a lot of losses. And I know that you're in employment law a lot, in business immigration, but some of the more interesting ones were in the very complicated issue of aggravated felony fraud or deceit offenses, where the amount of loss to the victim was over $10,000. Mm-hmm. The Third Circuit got really interesting in a case called Rad v. Attorney General of the U.S. It involved a new statute called the Canned Spam Act, which I just love that name for the statute. It just cracks me up. It's like canned spam, but it has nothing to do with spam, the food. And it's a very complicated case. I'm not going to get into all of it. I got into it a lot on the podcast. But what's most interesting to me is how the court really goes into and it really explains the difference between how federal judges sentence individuals and what's required for the $10,000 amount circumstance-specific approach. And it essentially says that sentencing documents in federal court are really different, and they can be based on anything. So when you have two different criminal charges and two different criminal offenses in an indictment, you can't just rely on the restitution order to make the $10,000 amount. A lot going on there. Kind of requires a background of aggravated felonies to understand what I'm talking about, I guess. But suffice it to say that the board can't always do, and IJs can't always do what they want to do, and that's just rely on the restitution order or rely on the federal sentencing document, because it's a really different document and it encompasses a lot of different things. And so Rad v. Attorney General of the U.S. is a great outline for really understanding all of that when you have a 101-843-MI aggravated felony issue. The 11th Circuit kind of went the opposite way in Garcia Simistera v. U.S. Attorney General on December 30th. And they essentially said that even when a non-citizen, it seems, pleads down to avoid the $10,000 amount, so they probably have pled to avoid immigration consequences, even when that happens, the board and IJ and the 11th Circuit can use the circumstance-specific approach to look at everything and to look at the indictment and to look at what was charged, even though that wasn't pled to. So they charged him with like a $200,000 conspiracy or whatever it was, but he pled to, $8,000. And the 11th Circuit says it doesn't matter, because in order for this charge to be sustained, it's very clear that there was a humongous loss, even though he only pled to an $8,000 loss, something like that. Again, I talk about it much more on the podcast where in the week that it was published. But that's the 11th Circuit going in the opposite direction, saying we can look at everything. We don't care what you pled to. So Garcia Simistera, if people are playing in this world, to me really highlights that if you're going to plead down for immigration consequences, at least where the circumstance-specific approach applies, and it applies at 101-843-MI and a lot of other removal offenses, you have to be really specific. You need a plea agreement that's really clear that that's the entire universe of facts. Maybe you need the prosecutor to draft up an entire new indictment. I don't know. Again, that's in the 11th Circuit, and so that's a smaller circuit. It does hit home though, because that is where the Kurzban firm, where I'm a partner, is based. So those are those two cases. Narrow applicability to people who are in the crimmigration realm, and so the bigger realm, back to asylum as there always is, was matter of AB issues. That's the Jeff Sessions case where they said that essentially tried to take away asylum claims for victims of domestic violence. To summarize that very quickly, 11th Circuit again started it off with Velasquez Alvarado, and they essentially deferred to matter of AB, said that Honduran women who have suffered domestic violence or Honduran women who are viewed as property is not a particular social group, just another nail in the coffin. Well, actually, that's a terrible phrase. Just another case that makes it very difficult for these type of individuals to get asylum. That is what it is. But what's very interesting is then what happened a week later. The acting attorney general, Jeffrey Rosen, issued matter of AB. He reissued it, so it's a second matter of AB. I guess matter of AB the second. And I know, John, that you posted it with the Immigration Lawyer Toolbox when it came out. And, he comes out swinging, which I'm stealing from former immigration judge Jeffrey Chase, who he noted on his blog. I think Acting Attorney General Rosen was a couple weeks before he was in the Department of Transportation, I think. It wasn't even the Attorney General, and there was a week before the Biden administration comes in, and they say we don't care, and he issues a blockbuster decision on asylum law, which, he clearly doesn't know much about it. How could he? He hasn't been an immigration lawyer, nor has he even been the Attorney General. So it's all. I think it pretty much sums up what the Trump administration's theory of governance was. Pretty nice metaphor for the Trump administration itself. And in this, please go on.
Yeah, I think the board immediately they're switching up. One of the main people of the board was kind of removed or something like that. I don't keep as close track. I post the news and stuff, but this stuff is beyond me because I never deal with them. But it looks like they're going to make some BIA changes. They're thinking about court packing on the Supreme Court. So we'll see what happens with the BIA and all that kind of stuff.
Well, so Director McHenry, so the director of EOIR itself, was moved to a sub-agency of EOIR, OCAHO, which, good riddance, doesn't affect removal defense practitioners. But so I don't think there's been a change at the board per se, but, another thing the Trump administration did was, through regulation, allowed the EOIR director to issue precedential decisions. Mm-hmm. So essentially, he's like a above the board, below the attorney general. I don't even know what it is, but it's a powerful role. The Director McHenry actually didn't really use it. The only decision that I can recall that he issued was in the OCAHO context. So, who cares about that if you're in removal defense?
Yeah.
So that is, I am not here for executive overreach. I'm really not. But if the Biden administration wants to combat the executive overreach that the Trump administration did in the immigration context, maybe use your new EOIR director. I also know that, I know that the Trump administration pushed out board members by offering them really nice retirement packages, which some accepted. And then they flat out packed the board. The Trump administration expanded the board and then picked very specific immigration judges to fill those new roles. So BIA packing has already happened. I don't know. What's good for the goose is good for the gander. I don't know. It all sucks.
Did the EOIR union, the immigration union, get closed off, or is that about to happen?
No, I think the IJ union doesn't exist anymore. The White House, as I understand it, trumped, or DOJ Maine trumped what the recommendation was locally. I don't know how all this union politics and union law works, but it seems like something that the Biden administration can and will change. And not only that, I don't know if you saw it, but the head of the IJ union, Judge Chavador out of Los Angeles, is now, I believe, the highest attorney in USCIS. Yeah. She has stopped being an IJ, and she's now DC. So I can only imagine that'll affect the IJ union somehow.
Yeah, we have a comment from our Facebook user. How long might it take to turn back the change at BIA, if at all? Yeah, we'll see. I mean, Trump was able to. I mean, it's easier to go down the Trump route to take it down as opposed to bring it back up. So it's much easier to destroy than to fix.
Well, I think it's much easier to expand than to contract. As I understand it, all the individuals on the board right now. First of all, I don't know any of these judges that they put on the board personally, so I'm sure that they are good people and they care about the law and all that. They just have a different view of the law than I do. But, they are, at the end of the day, they're bureaucrats, and it's not easy to get any bureaucrat out of their job, nor should it be. So, once you're on the board, it seems that once you're on the board, if you get taken off the board, you get placed, it seems to me, as an immigration judge in Falls Church, Virginia.
Yeah.
So that's where, all old board members go to hang out. Although in this case, a lot of these new board members never went to DC. They're in courts. So just thinking out loud, I don't think it would be that hard to just turn them back into immigration judges, but who knows?
Yeah.
And maybe, and I think the Obama administration tried the same thing. It seems that you do offer sometimes board members and bureaucrats nice retirement packages so you can then replace them if they accept it.
As you mentioned, Judge Tabador going to head the legal department USCIS. We'll see which direction that goes. I never practiced before her. I didn't practice much in the courts here in LA. I've been on panels with her, or I've seen her spoke. On a personal level, on one-on-one, and a group speaking. She's a wonderful person, very intelligent. I've seen her be critical of the immigration bar, which is rightfully so, because there's so much bad lawyering in the Los Angeles court right here. I mean, it's just one of those things where people do volume, don't even know who their clients are many times. And so she has to deal with that, which I understand. But we'll see how hardcore she gets when interpretation of law at USCIS. So she's coming to my turf now. We'll see what happens.
She's also a former EOIR attorney advisor, as am I. So, kind of pumped. But so is Director McHenry. So, we're not all good, I guess. But yeah, I don't know. I've said it before. I started my career 3 years behind the bench for EOIR, then in federal court. Like, you do see, you get a bit skewed. I've been fighting against it since I, went in private practice. When I was with EOIR, AILA, and still AILA is suing the immigration court, and rightfully so, in my opinion. But that is a difficult way to have a cordial relationship between the private bar and the immigration judges, when the immigration judges are getting sued by the private bar. I mean, you never see the Federal Bar Association sue the federal courts. I do think that I do not blame AILA. I don't blame the private bar. I think that just immigration law is kind of like that. But I hope that both sides can just tone it down and be more cordial. And I do also believe that starts with the private bar kicking out some of our less professional members, which we can't really do. But
yeah, because courts, there's just so much bad lawyering going on, and let alone people who are filing family cases, don't know what they're doing. But
and then notarios, it taints everything. You feel like your thumb is in the dam when you're on the other side, because the good lawyers, the good cases, those are you can rely on that attorney. But when you cannot rely on that attorney, it's essentially the immigration judge having to do everything, and they feel, I believe, exposed sometimes, and it just taints the whole process. So hopefully, I don't know. I'm all for public defenders for immigration clients, because then you'll get good attorneys getting paid, as a public defender rate. But it'll really up the entire thing as a prestigious profession, and that can't help but trickle down.
And maybe here in LA, at least, get a better building that looks nicer. When I go downtown, the building is so it's like little rooms in a house that they put courtrooms in. It just takes away from the legitimacy of it. Don't need to go there. So did you have another case you want to talk about?
Well, yeah, I was going to get into matter of AB with where it's acting Attorney General, Department of Transportation Attorney Jeffrey Rosen did say about it. And as I see it, it was really two big holdings. First, he's reaffirming Attorney General Jeff Sessions' complete helplessness standard for the unable and unwilling to protect standard required to obtain asylum. But in doing so, he's trying to walk a fine line with the Grace v. Barr litigation out of the D.C. Circuit. And to walk that line, again, this is just as I read it, he's saying that unlike what the D.C. Circuit said, Jeff Sessions didn't change the unable or unwilling standard at all when he said complete helplessness. All he did is he renamed it, or he's using another phrase. So I don't quite understand what the point of that is, according to Jeffrey Rosen. So he's saying nothing has changed since matter of Acosta in 1985 with unable and unwilling. Jeff Sessions just wants to refer to it as complete helplessness. All right, fine. But then he goes on to explain what he believes complete helplessness or unable or unwilling has always meant. So he's saying nothing has changed, but what you thought it meant is not what it meant. So it's a clever lawyer's tool. I don't know if that'll withstand clearly attacking Grace v. Barr with that. And then he goes on to go to the nexus requirement, saying essentially, in order for you to obtain asylum, for there to be a nexus to a protected ground, the protected ground must, one, be the but-for cause of the action, and two, it must play more than a minor role. It cannot be incidental or tangential to another reason. And apparently that's in conflict with law in the Fourth Circuit, which puts a lot of stake just in the but-for cause prong. And so he's attacking, acting Attorney General Jeffrey Rosen in the last week of the Trump presidency, after being in the Department of Transportation shortly before. He then cites to Brand X and really goes after a bunch of circuits, including the D.C. Circuit, the Fourth Circuit, and I believe other circuits, and says, my opinion on all this trumps your opinion, to use a bad word. And you have to listen to what I say. And Brand X allows the Attorney General to do that so long as the issue really is ambiguous, which it probably is, and so long as his interpretation is reasonable, which I don't know. Maybe it is, maybe it isn't. In Amaya v. Rosen, the Fourth Circuit case I talked about at the beginning of all this, the Fourth Circuit said that matter of WGR was not reasonable. So maybe reasonableness will be the battleground for matter of AB the first, matter of AB the second, or maybe a Biden or maybe Merrick Garland just takes away matter of AB entirely.
Mm-hmm.
I mean, it's a whole new world.
Yeah, anything is possible. One case we've always been talking about is the issue of TPS. And I said this has got to go to Supreme Court. And Supreme Court has taken it on. So we're going to get a decision on whether TPS is admission or not this year. Be careful what you wish for, I guess. But I'm optimistic based on nothing really other than my gut that it's going to go towards TPS being an admission. That just makes sense to me. And I think the composite of the court right now may go in that direction, but you never know what's going to happen. It's a black box of what would anything come out of that one. But that was interesting that they finally made a decision to go forward and to decide that.
Yeah, absolutely. Oops, sorry, let me turn this off. Being live. I am not going to guess on admission. Admission means 10 different things now based on BIA and circuit precedent and even the Supreme Court. So I think that if I'm a policymaker, I think that deeming TPS an admission for purposes of immigration law is a nice compromise on what to do with the TPS issue. I think a lot of people, myself included, would like that this whole group of hundreds of thousands of TPS beneficiaries do have a path to a green card with or without a qualifying relative. But if we have to compromise, I think finding it an admission, thereby allowing it to be a path to a green card, at least for those with qualifying relatives, I don't know, maybe that's a decent compromise and that Congress can't make because Congress can't compromise on anything.
They're backing out of maybe comprehensive immigration reform, the bill that Biden, that we haven't read, just to read the synopsis of it, is putting out, maybe putting in pieces and taking stock on TPS maybe separately. But that would be something immigration lawyers would want, that TPS always be admission, and just specify what TPS is and embed our language in there. We'll see what finally comes out of that.
Yeah, we've talked before. It's a double-edged sword, right? If TPS is expressly an admission, maybe that then makes it more difficult for administrations to grant TPS to entities, although I don't think Republicans are granting TPS to anyone anyway, so maybe that ship has sailed. But, Ira Kurzban, who's founding partner of my firm, as everybody knows, he is active. He's on the board. He's one of the founders of an entity called Immigrants List. It's a political action committee with Sui Chung and other individuals, mostly in South Florida. And, they've been very active over the last over a decade in, providing money, support to congressmen and women, senators. I think Senator Duckworth is Duckworth, I hope I got that right, is the highest profile individual. But last week they had a Zoom with Congresswoman Jayapal, who I believe is leading the Progressive Caucus in the House. And she was talking about how maybe we're not going to go comprehensive immigration reform. Maybe they are going to try for a piecemeal approach. And maybe that's the better decision, because they were really close to comprehensive reform in 2015, and they got tanked by a minority of Republicans in the House in the Freedom Caucus. And they have only gotten more powerful, it seems, since. The Republicans have done piecemeal immigration reform since 96. I mean, the Real ID Act added in a bunch of little things in immigration. I mean, maybe that is the better approach. I'm not a congressperson, but
I think it is, because the comprehensive, we're going to get squashed. We don't know what's in it. There's too much stuff, because the stuff we need is so detailed that it's hard to put something back that big and try to argue small parts of it. I personally prefer piecemeal if we just get something done. I mean,
I'm a little worried what comprehensive immigration reform looks like. I mean, you got to give to get. What are they? Is there going to be 65 new criminal bars to? I'm a little scared what that looks like.
So I say it's thick. Now, one thing on federal court cases, I track what's going on with gun cases when it comes to immigration. It's like a little side thing I have. I keep track of cases, and we had a decision in the Ninth Circuit. I think it was named Greer or something like that. And to back it up, the federal statute on gun possession, it generally says if you're a non-citizen, if you're not a green card holder or U.S. citizen, unless there's some sort of exception, it's federal offense to have a gun. And so a lot of people are getting busted on this, but Supreme Court 2 years ago said that you have to have knowledge, because the statute has a mens rea aspect of it, which is wonderful that they did that, because a lot of people don't know. They go to a shooting range, and just by going to a shooting range, all of a sudden they're deportable. And so that's something, if your clients have a gun, they should dispossess themselves of it once they have knowledge that it's against the rules, and it still will be fine. In this case, Ninth Circuit, the guy was on the H-1B, was bragging about having a gun and knowing you can't. Apparently, he was convicted. There was problems with the jury instruction, not mentioning the mens rea aspect. But the court in Ninth Circuit said, you know what? The guy put himself out there that he knew it was the rule anyway. So the jury instruction didn't make a difference anyway, because the facts were that. But I just want to add that, if you have cases pop up where your clients have, had guns, and if they go to a USCIS marriage adjustment interview and that officer asks, have you, been to a shooting range before? That's not something that's a crime unless they had knowledge that it was a crime. So don't, it's a lot of misunderstanding, lack of knowledge on this area. I thought I'd share that. And TPS through Syria got a TPS renewal, FYI. So just share that little knowledge real quick.
I'm no expert in the gun cases, and they it rarely comes up in the immigration context, at least in a published decision. But I do like when it does come up. I can't remember it, but I think a couple of years ago there was a very favorable decision out of either the Fifth Circuit or the 10th Circuit. One of those Western states, more libertarian leaning. And I just like the thought of when those cases come up, with the judge, maybe a judge who doesn't have a progressive view of immigration, but who has a very progressive view of the Second Amendment. I just like, maybe their head explodes. They don't know what to do. They're caught between a vice. I do enjoy it. And it usually falls on the side of Second Amendment protections that are then very favorable to the immigrants. So I do like, and it happens with, it seems, Justice Gorsuch a lot, when their principles they're not necessarily progressive on immigration issues per se, but their principles sometimes lead them down that path de facto. I really enjoy that.
Yeah, the immigration legal issues are always really interesting because of that. It's like the ugly stepchild that no one knows which way is going to go, or I'm not even sure that's a proper analogy or sample, but just this random part of a law that is just so political yet so legalese at the same time. It's insane.
Yeah, that's why we can talk about it on a podcast for a half hour, 45 minutes. I don't know.
Well, before we go, anything else going on with you? If you want to catch up, what's going on with Kevin Gregg? I saw you had a guest on your podcast. So are you switching up, having other kind of stuff as well than just purely federal like litigation?
Well, every week I do all the cases, review all the cases as always. That's not going to stop. I'm on episode 40 of it's just insane. I don't know how that happened, but every single week. But I'm also trying to add in a special episode, and over the last couple months, it's turned into once a month. As you know, it's a lot of work.
Yeah.
I don't know if I'll be able to keep up once a month, but this has all been kind of because of the pandemic, being indoors. That I've had, I don't know if I've had the time, or I don't know if it's actually given me more time, or I've just given up my weekends. But I did do an interview with my co-partner at Kurzban, Ed Ramos, who is just a federal court genius with a jurisdiction and standing. So we dropped that one last week, and I'm going to try and do that at least once. I'm going to try and do that once a month if I can. If not, so be it.
Yeah, what I found is the interviews are really good, developing a good relationship in the bar, and that's pretty much like a big part of like my podcast, just meeting people and talking with them. It's especially when you're full solo like me at home and no partners or associates, that's good to reach out and just touch somebody and talk with them.
I found a similar thing with reading. I read every case now every week for the podcast, and so it keeps me very sharp. It helps me too, just like that. It helps me just like it hopefully helps everyone else.
Yeah. And one thing I do when I read these cases, like federal court, I try to reach out to the lawyers on it too. Most of the time, they don't respond, surprisingly, because I'm like, "Oh, come talk about it," or publicity out of it or something like that. But every once in a while, we'll meet and privately we'll have conversations. So I get to know a lot of these big hitters that are going for Supreme Court cases and stuff. It's good to promote these kind of attorneys that are not sitting still and trying to make some changes.
That's right. For a while I was trying to tag them on Twitter.
Mm-hmm.
I just lost the time. I'm saying their name on the podcast now, but not all of the cases that get published say the attorney's name. It ends up doing it on Westlaw, weeks, months later, but I don't ever look at it on Westlaw. So with the circuits that list the attorney's names in the PDF, I say their names now with a win.
But and the Twitter plug is good for your own marketing too, because if they share it and stuff. But what I found, it's going to marketing stuff. Like I'll tag people like stuff they did, and you think they'd share it to give a publicity, but so much of the immigration bar, especially lawyers, that are just not attuned to the publicity that come in attention and business marketing aspect. I'm like, well, just reshare this. Someone's going to see it, and then you're going to get more business out of it. But it just everyone's so cop and work, and the social media stuff is just so new. People aren't too much into it yet.
Just another thing, the more I know of this world, the more I'm like, oh my God, just so much.
You were talking about it beforehand for the live show about how do you do all of it. I'm like, well, I just got to practice less. And so that's not a practice less.
Right. Yeah. That's what you got to do. Just stop practicing law.
Well, thanks so much, Ken. I'll see you again next month. Hopefully some good cases. And until then, everyone, thanks for listening. Stay on the line. I'll turn off the live feed, but it was really fun doing live and no editing. I don't think we said anything that needs editing, so we'll go keep it on the feeds.
Yeah, no, I liked it a lot, and I hope I didn't disappoint that at least one viewer who's looking at me for the first time.
I'm sure he did. All right, everyone. This audio will be on the podcast too. Almost everybody listens to the podcast video, but we'll be there in probably 24 hours or so. Bye, everyone. See y'all soon. End podcast.